take our seats. We want to get started on time. Y'all are worse than my property class. Then again, with them, I put up a PowerPoint where they can take a little survey. And today's question was, what was the quirkiest part of class so far? And what I thought would have won was my, unflailing obsession with science fiction. But anyway, you're not here to hear about my little idiosyncrasies. You're here for the Battisti Memorial Lecture. So for those of you I don't know, my name is Atiba Ellis. I am a professor of law here at the law school, and I come to you today in my role as the Associate Dean for Engagement and Enrichment here. So in that capacity, and on behalf of our Dean, Paul Rose, it's my great pleasure to welcome you to today's Frank J. Battisti Memorial Lecture. Let me start by saying a word about Judge Battisti. He served on the U.S. District Court for the Northern District of Ohio for 33 years. And he was chief judge of the Northern District for most of that time. During his time on the bench, Judge Battisti handled some major cases, including the long-running Cleveland school desegregation case, important fair housing litigation, and lawsuits involving the location and operation of public housing in and around Cleveland. Although he was a graduate of a certain other well-known East Coast legal education institution, Harvard, Judge Battisti was a great friend of this law school. He hired a number of our graduates as his law clerks. Indeed, this lecture came about precisely because of the devotion of his many former law clerks. They are the folks we have to thank for endowing this series. And the Battisti lecture has a storied history in and of itself. We have had at Case Western an array of distinguished lecturers in this series, both practicing lawyers, law professors, and folks from other fields in which Judge Battisti had an abiding interest. Previous lectures have included Judges Leon Higginbotham, Nathaniel Jones, Solomon Oliver, and Jack Weinstein. The lecture has included legal scholars like Lee Bollinger, Erwin Chemerinsky, Justin Driver, Jamal Green, and Michael Klarman. The lecture has also featured civil rights legends such as Julian Bond and Fred Gray, among many others. So I welcome you to this talk in this continuing and rich series. To introduce this year's Battisti Lecture, may I present to you my colleague, my friend, and the director of the Case Western Reserve University Social Justice Institute, Professor Aisha Bell Hardaway.
Hi, everybody. Thank you so much for being here. Dylan C. Pennegroth is Professor of Law and Morrison Professor of History at the University of California, Berkeley, and an affiliated research professor at the American Bar Foundation. He specializes in African American history and legal history. He's a MacArthur Fellow. His most recent book, Before the Movement, The Hidden History of Civil Rights, explores how ordinary Black people used and thought about law in their everyday lives, and how Black legal activity and Black legal thought helped shape American law and Black social movements from the 1830s to the 1970s. It's been awarded 11 book prizes and was shortlisted for 4 more. His first book, which is how I know him, The Claims of Kinfolk, of African American Property and Community in the 19th Century South, won the Avery Craven Prize from the Organization of American Historians. His articles have appeared in the University of Pennsylvania Law Review, the Journal of American History, the American Historical Review, and the Journal for Family History. Dr. Pendergrass has held fellowships from the National Endowment for the Humanities, the National Science Foundation, the Stanford Humanities Center, and the MacArthur Foundation. Before joining UC Berkeley in 2015, he was on the faculty of the History Department at the University of Virginia. He was also at Northwestern University before that, and as I mentioned, serves as a research professor at the American Bar Foundation. At Berkeley, Dr. Pendergrass has had the privilege of advising PhD students in both the History Department and the program of Jurisprudence and Social Policy on a broad range of topics. Please join me in giving Dr. Pendergrass a warm welcome.
Well, first of all, I think I should say thank you. Thank you so much, Aisha Hardaway. Thank you, Dean Rose, Eric Seiler, Tiba Ellis, and the entire Battisti Advisory Committee for inviting me here. I really appreciate it. And I also want to say thanks to all of you for choosing to spend an hour of a very beautiful, sunny September afternoon with me here. Thanks most of all to the family and friends of Judge Frank Battisti. I hope that these remarks will honor in some way his spirit of rigorous, open-minded inquiry in pursuit of the highest ideals. So let me begin my subject, let me introduce my subject with a story about another judge who sought as best he could to honor his oath and the Constitution, Thurgood Marshall. So I think it's a few days after Christmas in 1973, and here America's first African-American Supreme Court justice sat down with a white journalist named Richard Kluger for an interview about Marshall's most famous case. It's been 20 years since Marshall had argued Brown versus Board of Education of Topeka, and when he had done it as head of the NAACP's legal team. And ever since the day it was handed down in 1954, white critics from all over the political spectrum had accused the Supreme Court of behaving like 9 politicians in robes, imposing their personal values untethered from statutes and legal precedent. Many critics singled out a footnote, footnote 11. And that footnote cited psychological research purporting to show that segregated schools damaged Black children's self-image by fastening onto them a badge of inferiority that could not be removed simply by making the schools equal. So Kluger asks Marshall the question that was on everyone's mind. How did the NAACP's lawyers decide to rely on these so-called dull cases? Marshall didn't hesitate. He said emphatically, quote, "I said that we had to try this case just like any other case with damages. Just as if your car ran over me, you'd have to pay up." So I'm sitting in the archives at Yale a few years ago, and I'm thinking to myself, come on, Richard Kluger, ask some follow-up questions. But no, Kluger moved right on. And when his book came out a couple of years later, it was titled Simple Justice. And it was about the brave Black folk and their NAACP lawyers who waged Black America's struggle for equality. The struggle, according to Kluger, was simple and it was sacred. But I kept wondering, why was the hero of the sacred struggle for equality talking like a personal injury lawyer? And now, years later, I think I understand. It's because he wasn't just talking to Kluger. He was talking to Black people in Topeka and all across America who knew perfectly well what a personal injury lawsuit was. Now, that statement might seem a little surprising today because I think we've lost touch with the world that Marshall lived in and worked in. Kluger's Simple Justice was an early entry in what has since become the grand narrative of African American history, an unfinished freedom struggle, a journey from second-class citizenship to full citizenship, from Black fear in the face of white lawlessness to Black people defiantly asserting their rights under the law. The story goes, once the legal system was dominated by racist state and local officials who refused to recognize not only Black people's civil rights, but their basic human dignity and even their lives. Law was a hostile, fearsome power, something you should avoid if you were Black whenever possible. It was full of unknowable secrets. It was often deadly. Then, in the 1940s, a few brave lawyers ventured south, bent on changing the law. And then soon, ordinary African Americans, their sense of possibility awakened by Brown and other Supreme Court victories, and galvanized by racial justice activists, coalesced into a mass movement demanding that the federal government force those racist state and local officials to recognize Black people as free, full members of American society. This, I would submit to you, is the master narrative of civil rights and of African American history. And it's not wrong. At some level, it is not wrong. Police are still killing people. And now political leaders are openly attacking bedrock anti-discrimination laws like the Equal Employment Opportunity Act of 1965. Movement-centered scholarship is as urgent and necessary today as it was in the 1960s. But I also think that thinking of Black history as a freedom struggle has also cost us something. It makes Black history almost equivalent to race relations, as if Black lives only matter when white people are somewhere in the picture. It lays a moral burden on African American history that few other scholarly fields have to carry. It urges us to judge our ancestors according to how well they advanced the freedom struggle. It segregates the law curriculum, slotting race into public and constitutional law and making private law seem white. And most of all, I think, it has shrunk our vision of Black life down to the few areas of Black life where federal law and social movements made a difference. In the freedom struggle story, Black people are portrayed as untutored in law and alienated from the legal system. In fact, they're seen as ordinary and heroic precisely because they knew so little about law. But if that is so, then why, when a mass movement against racial injustice finally took hold in the 1950s, why did so many Black people put their faith in law at all? In different ways and for different reasons, I think that both legal scholars and US historians have left Black people disconnected from our own legal common sense, the way that we actually think about and use law in our daily lives. And that, I think, has made it harder to see Black people as people in full. Today, I want to propose to you that long before Brown, long before the movement, Black people routinely used law, talked about law, thought about law. Just as Marshall implied in 1973, civil rights lawyers and activists actually counted on the fact that ordinary Black people knew something about law because they used civil rights all the time. Now, what do I mean by that? When I say the term civil rights, I'm not talking about the ones that we think of today as civil rights. The ones I'm talking about, or at least they weren't conceived at the time as being about protection against discrimination or subordination on the basis of race, sex, or other protected categories. Instead, I'm talking about what one of the framers of the 14th Amendment called the ordinary rights of a freeman, the basic rights of contract, property, and standing that Congress wrote into America's first national civil rights law, the Civil Rights Act of 1866. These were rights that people exercised not just in court, but in their daily lives, although in practice they rarely had much reason to refer to them out loud as civil rights. So, for example, when my great-great-aunt Annie Holcomb paid my mother's burial insurance policy each week on her doorstep in South Orange, when she and my great-great-uncle Thomas Holcomb sold land to Midway Baptist Church in Southside, Virginia, when they wrote down instructions about how and where they wanted to be buried on that land. In other words, every time they did something that a court could protect, they were doing civil rights. They were exercising freedom, making it mean something more than the negation of slavery. Civil rights were rights of everyday use. And what I also want to propose to you is that the meaning of civil rights then changed over time. It changed from meaning the rights of free men to the right not to be discriminated against, a separate, set-aside body of law. So if you think about it, in the 1800s, most Americans understood rights to exist in three baskets: civil, political, and social. The last two were off limits. And the traditional story focuses on those. You think about social rights, white supremacists tended to talk about things like integrated schools or railroads, streetcars, as being in the realm of the social, equivalent to having to invite someone into your home, right? And political rights, think of things like voting, the right to hold office. Scholars have tended to focus on those two categories. They focused less on the first category, the civil. So that's where I started. And I began this research with a simple question: did Black people go to court? And right away, I ran into a very big problem, which is that legal documents typically don't identify people by race. Not even in local county courts in Mississippi. Now, this is kind of a surprise, right? Because this is the place deep south where even the water fountains, C. Van Woodward showed that they even had segregated Bibles for people to swear on in court. But the books, the docket books, do not mark people by race. Now, there's some big analytical and conceptual issues here, which we can talk about later if you want. But the immediate issue was practical. I wanted to write Black history, and I couldn't tell who was Black. So to get around it, I would get on a plane, I would land at the airport, I would hop in a rental car. Those of you who know rental car agencies these days, it's always a Malibu. They give you a Chevy Malibu no matter what you ask for, and it kind of hurts my neck because I'm tall and seat cushions. But anyway, I get in the Malibu and I drive and, have to stop and take pictures of interesting things along the way. I'd show up at the office of the circuit clerk, and then if they let me in the back room, I would start to pull down docket books at 10-year intervals, and I would copy down the names on a subset of the cases for that year. And then I gave those names to my research assistants to look up on Ancestry.com. So that's the online one where you type in, not the swab one, the typing one. And so they looked them up, and we started to find people. Once I had a list of cases involving Black people, I went back to each courthouse, and I read some of the trial records where it was available. Now, it wasn't foolproof, and I think you can see why. No historical method is foolproof. Sometimes it was kind of gross. It's like things I had to dust off my hands. Anyway. But gradually, over time, we started to see a picture of when and where and why Black people used the courts. By the end, we looked up more than 14,000 civil cases, focused on civil cases, from 24 courthouses in 5 states and the District of Columbia. And we identified more than 1,500 that involved Black people. So, race ducks in and out of Westlaw, and it is pretty much invisible in the county court dockets. This is how we made it visible. Now, in fact, we found more cases involving Black people during the Jim Crow era, during Reconstruction. Trend line is going up. Black people used their local courts for all kinds of things, much as white people did. They used them for divorce, insurance payouts, railroad accidents, unpaid rent, personal property. They also used the courts they used private law in more routine, non-adversarial, non-court-based ways as well. So they sold easements on their land. They made wills and they got them probated. They had cars towed off their property. They sorted out home building contracts, drunk driving charges, and landlord-tenant disputes. And of course, they bought, sold, and gifted land. Okay. By now you might be asking yourself, why would white Southerners, why would people in Mississippi let black people do this? Why let black people exercise their civil rights seemingly without complaint or even comment? Well, it wasn't out of a sense of fairness, and it wasn't out of a sense of paternalist obligation. And it wasn't, I would submit, because formal legal rules somehow trumped white racism. The reason white people recognized black rights is because life's ordinary business could not go on if whites could not make contracts and convey property to black people. African Americans' property and contracts had legal meaning. That is, in a very real but limited sense, black lives mattered to whites. White people who sought to murder or intimidate or cheat black people out of their property could certainly do it, but then they would have to contend with the interests of other white people as defined by particular legal rules, rules that were broadly understood as part of the common sense of law. The overwhelming majority of the cases involving black people, moreover, were between black people. Only 8% of the cases in my Jim Crow sample crossed the color line. And this is another reason, an important reason, why white Southerners allowed black people to go to court. And yet, even as white local officials cut them off from formal schooling, right? This is the Jim Crow South, after all. Black farmers took pride in having what Nate Shaw, an Alabama tenant farmer, called goat sense. And I like to think of this as being something like the common sense that God gave a billy goat, right? The rough and ready legal knowledge that most grown-up people possessed to varying degrees. I'm not saying that Shaw is an expert in law. I'm saying that he's a grown-up in a world where grown-ups know certain things about how law works. For example, Shaw knew that each party to a joint promissory note is liable for the other's debt. He knew that a husband's mortgage did not cover household goods unless his wife signed too. And he knew that a renter at the end of his lease had the right and the privilege to take anything that ain't tied down. Each of these statements, which come from his autobiography, tracks neatly with the relevant Alabama statutes. And that goat sense was refined through daily experience and discussed in churches and schools and black-owned newspapers. For people like Nate Shaw, steeped in the everyday of private law, it made a certain kind of sense to say that Brown versus Board of Education was just like any other case with damages. In other words, African Americans cared deeply about law and order. Not the law and order that today's Republicans use as a code for anti-black policies, but the law and order that the Reverend Joseph H. Jackson, head of the country's biggest black religious organization, talked about in the 1960s. The law and order that led hundreds, if not thousands, of African Americans to file civil suits in county courthouses in the century after the end of slavery. After all, what they suffered wasn't just over-policing, it was also under-policing. The problem of getting the law to redress the wrongs committed against them. For African Americans, property and contract were civil rights. And they hammered out their relationships with white people and their relationships with one another within the law, through the law, not just in struggle against the law. Now, black people's engagement, their long engagement with these rights of everyday use, had some big implications, and I'm only going to mention two in the time remaining to me. First, it laid the groundwork for civil rights litigation and the mass movement that began in the 1940s and 50s, what later becomes known as the freedom struggle. But then the freedom struggle unfolded in a way that hid those contributions, that groundwork. Second, black people's legal activity helped make the law, not just public law, but also private law, such as the law of contract. But then, for their own professional reasons, lawyers, judges, and other legal professionals obscured black people's contributions to private law as well. So, right from the beginning, civil rights lawyers decided to put the rights of everyday use outside the category of civil rights. So in 1912, the NAACP's Legal Bureau, that's what it was called at that time, set, quote, a general policy, which was to turn down, again quoting, cases which do not specially involve the Negro question, but come to you simply because a Negro is involved. So they're writing to their branch lawyers and sort of setting out a standard for when the organization can take on a case. So W.E.B. Du Bois, a decade later, explains the policy with an example. The example goes like this. The Legal Bureau receives a letter from a widow who is facing foreclosure on her home. The NAACP could not help, Du Bois says, with these purely civil and personal matters of property. It has to save its precious legal resources for cases, quote, involving discrimination and injustice because of race or color, cases that would set precedents for the rights of colored people as a whole. The trouble, of course, is that black people kept pestering the NAACP for help on all kinds of legal issues, from murder cases to abusive railroad conductors to the widow staring at foreclosure on her house. But the NAACP stood firm. As painful as it was, Du Bois wrote, the Legal Bureau had to rule out these cases of, quote, injustice to individuals who just happened to be black. The idea was self-reinforcing. Once black rights were defined in terms of anti-discrimination, then, almost by definition, cases involving property or contract or other black people became purely civil or personal. By the 1960s, the rights of everyday use were becoming crucial to the mass movement. So, for example, black landowners let out-of-town activists turn their spare bedrooms into offices and their farms into meeting grounds. They signed bonds against their farms, these black property owners. They signed bonds to bail civil rights workers out of jail. They fed the marchers out of restaurants that they owned. And they often worked very hard on voter registration drives. The famous Voting Rights March of 1965 from Selma to Montgomery, Alabama, might never have happened if black landowners along Highway 80 in Alabama had not given marchers permission to camp on their land. Now, the activists are watching in helpless admiration as the landowners are losing their cotton crops, their jobs, their mortgage loans to a series of full blast economic retaliation from the local white power structure. And so these out-of-town activists are trying to make sense of what they're seeing. And they find their explanation in culture. The activists figured that some black people were already primed to get involved in the movement because they had grown up in landowning families, relatively protected from white racism and unafraid of it. So in Madison County, Mississippi, CORE activists, that's Congress of Racial Equality activists, were awestruck by a man named C.O. Chin, a restaurateur and landowner locally known as, quote, the type of person that didn't take shit from anyone.
I like that way you say that.
Exactly. In Holmes County, there was Hartman Turnbow, who in spring 1963 fired back at white terrorists and then warned, this is quoting from another book, warned the sheriff and everybody else that anybody he caught on his land after dark was going to get lit up like a Christmas tree. Now, the SNCC activists are hugely impressed by this kind of bravery, and they come to believe that landowning has instilled in black farmers a certain independence that sharecroppers lack. Sharecroppers, they said, suffered from the plantation mentality, an ingrained sense of helplessness and dependence on whites. Now, of course, in the mid-20th century, such cultural theories were everywhere. From the Marcus Garvey's idea that racial oppression produced mental slavery, to the Moynihan Report's assertion that the crumbling of the Negro family in the urban ghetto was seeding a culture of poverty, and to the Supreme Court's urgent warning, driven home by Marshall's account of the doll tests, about the harm that school segregation was inflicting on the hearts and minds of Negro children. Movement activists, especially those who had not grown up in the rural South, passed their cultural theory of black landowning, along with their open admiration for plain-spoken local people. They passed these assumptions on to scholars. The cultural theory explained and justified what they, the activists, were doing in the South. Now, to be clear, the activists' views on the matter were complex. Some SNCC activists derided what they called local peopleitis, the romanticization of poor Mississippians, and they called it an excuse for SNCC's own inaction and disorganization. Bless you. Some civil rights workers understood that the local people they were trying to teach were already quite familiar with legal concepts and legal rules. And yet, movement activists and writers often interpreted local people's behavior in nostalgic, almost anti-legalist terms, as part of a Southern way of life that they believed had kept generations of black Southerners alienated from the law and afraid to approach the courthouse. Again and again, the movement lifted civil rights up from the house porch and the county courthouse into the universal values of freedom, justice, and dignity, and then returned them, transfigured as moral arguments. Now, something got lost in that transfiguration, and that is the long, rich history of black people's legal experiences and ideas about rights, as well as their relationships with one another, and not just with white people. And so activists bequeathed to us what I think are three deeply flawed assumptions. First, that common law rights under state law and the local courts that judged those rights had been a closed book to black people before the modern freedom struggle. Second, that those rights were not civil rights. And third, that whatever they were essentially irrelevant compared with protection from discrimination or subordination as defined by Congress and the Supreme Court, much less compared to the broader human freedoms that activists were now seeking. Now, for their part, white legal professionals did not transfigure the black legal experience, they buried it. In this, which was, after all, the formative era of modern contract law, leading law professors, judges, and legal commentators actually cited black people's cases as precedents across a wide range of doctrinal areas. But they almost never mentioned that black people were party to these suits. They silently passed them into legal doctrine. Now, stripping out racial facts influenced the legal doctrines that these cases established. It enabled some doctrines to sweep wider than they otherwise might have, and it enabled others to be hemmed in, and it shaped how lawyers and judges understood these cases. Now, legal professionals, of course, were perfectly free to do this. The new federal laws, the Civil Rights Act of 1866, the 14th Amendment's Equal Protection Clause, the Ku Klux Klan Act of 1871, all of these seemed to say that no state could create separate bodies of contract law for people of different races, but Congress never said that courts had to ignore race. And so ever since, legal professionals have been making up their own minds, case by case, about when race matters in contracts. In practice, lawyers and judges tended to invoke race or reveal race opportunistically, depending on which position seemed likelier to help them win the case. So, for example, in the slaughterhouse cases, Justice Miller insisted that the Civil War was fought over African slavery and that the 13th, 14th, and 15th Amendments were all about race. Their one pervading purpose, this is his words, their one pervading purpose was the freedom of the slave race, the security of that freedom, and the protection of the newly made free citizens from their former masters. Now, of course, by contrast, the lawyers for the plaintiffs talked about everything except race. These guys are ex-Confederate butchers, and they're challenging a new Louisiana law, if you don't know the case, that to protect the public health, consolidated all of New Orleans' livestock slaughtering at one place. And these guys' brief is a mishmash of white grievance politics. It's kind of a greatest hits album of the history of oppressed white people, going back to the ancient Romans, believe it or not, through to medieval peasants during the reign of King Richard II. It's amazing. You should read it. The point, of course, was to show that the slaughterhouse regulation imposed, you ready? A kind of slavery onto small businessmen. Now, the slaughterhouse cases showed that lawyers and judges could widen or narrow the scope of a constitutional provision by manipulating the materiality of race. Smart lawyers figured out that they could do the same thing in private law too. So consider the 1916 case Southern Express Company versus Byers, where the United States Supreme Court barred contract damages for mental anguish as a matter of federal law. So here we have John Byers. He's a black North Carolinian, and he sues the Southern Express Railroad for failing to deliver a silver gray casket, robe, gloves, and hose in time to bury his wife, who had died suddenly while visiting her mother in South Carolina. His lawyer made sure to get it into the record that John Byers was black. But when the case reached the Supreme Court, Justice James McReynolds erased that fact. McReynolds, for those of you who don't know, was one of the most flamboyantly, opulently racist people to ever sit on the court. He frequently used racist language in other contexts. And yet in Byers, he did not say a single word about race. He hid John Byers' race because he wanted his pro-business holding to frustrate not just black plaintiffs, but any plaintiff who was seeking contract damages for mental anguish. He wanted it to sweep wide. Now, Justice Miller highlighted race, and Justice McReynolds suppressed it, but each of these men's choices illustrates how opportunistically race has been treated in law. Casebook authors, of course, had to make choices too, and they were constrained to an extent by what the source materials disclosed. So, for example, the 1972 edition of Fuller and Eisenberg's Basic Contract Law featured several cases involving African Americans. For example, in Taft versus Hyatt, which the casebook used to teach offer and acceptance, the person who is described as a member of a Masonic lodge was actually a member of a colored Masonic lodge, which was trying to protect him from a lynch mob. On page 255, in the section on past consideration, there was Harrington versus Taylor, where the plaintiff sued on an oral promise to pay damages after she had injured her hand, saving the defendant from being decapitated by his wife. It turned out that all of the parties were black. And then there was Ricketts versus Pennsylvania Railroad, where Judge Jerome Frank used a railroad waiter's attempt to void an accident release as an opportunity for a grand comparison between the will theory and the objective theory of contract. I ordered Sidney Ricketts' pension file from the National Archives, and he was black too. But the students couldn't have known that, and neither could their professors have known it. My point goes beyond case selection. It goes beyond critiques of erasure. Many of the cases reprinted or cited today in first-year casebooks were chosen during the decades between the end of slavery and the end of Jim Crow, and the cases were not chosen because they were representative or even because they were frequently cited by courts, but because some Ivy League professors thought that they illustrated certain legal principles. Principles that were themselves forged in a decades-long legal theoretical struggle over the meaning and limits of market freedom in a post-slavery society. Core concepts of capacity, voluntariness, and coercion are deeply rooted in what Bill Nelson memorably called the jurisprudence of anti-slavery. Now, in their editing and case selection, the casebooks inadvertently muffled the role that black litigants and racial ideas and the legacy of emancipation had played in the development of contract law. Indeed, it's helpful to keep in mind that what got reprinted in the casebooks was only the last in a string of decisions about whether and how to talk about race. Decisions that got made at every stage of the legal process by litigants, by lawyers, trial and appellate judges, casebook and restatement authors. Similar to the way that some colored people were allowed to pass as white, some colored cases got passed silently into the heart of contract law when legal professionals elided the fact that a litigant was black, and when they turned slavery into an abstraction detached from race to make a theoretical point. The result was to make civil rights and contract seem like completely separate categories of law, darkening one, whitening the other, and impoverishing both. And that, in turn, encouraged white students to think of race as something tangential to real contract law. Whether it was made out of embarrassment or a desire to modernize law teaching, law professors' casebooks and classroom choices treated black students in the 70s as guests to a white limestone cathedral built by white men. In the fall of 1972, when those students opened their contracts casebooks, the only case that even hinted that black people were involved was in the section on unconscionability, Williams versus Walker Thomas Furniture. Why does this matter? I think of a lot of reasons. I'll just give two, and I'll close. First, I think that studying this subject can help desegregate American law. Black people's engagement with law denaturalizes some legal categories. Contract and property are not white, of course. They only look that way to some extent because certain legal professionals treated civil rights as a special minority-focused body of law, veiling along the way what cases brought by black people had contributed to core areas like contract. They look white because law professors and historians implied that black people encountered law meaningfully only in criminal justice, voting, the workplace, schools, and public accommodations. That is to say, they only encountered law in cases that were about race. Second reason I think this matters is that once we see how long legal professionals have been grappling with when and how to recognize race, the perceived choice between race-conscious and color-blind approaches to law starts to look a bit like a false dichotomy. Today, Jim Crow is gone, but one could argue that the Roberts Court is continuing the old pattern of opportunism. The Roberts Court insists that government recognition of race is equivalent to discriminating on the basis of race. And yet, as my colleague Chiara Bridges has shown, the court's conservatives do frequently talk about race. They equate abortion with genocide. They claim the 14th Amendment was enacted partly to ensure freed people could arm themselves against the Klan. And in affirmative action jurisprudence, they have been dwelling on, quote, the feelings of disappointed white applicants, end quote. The scope and stakes of racial opportunism are only growing now that the Trump administration is redirecting federal agencies to investigate discrimination against white people, for example, and prioritizing Afrikaners for refugee resettlement. Once we stop pretending and frankly acknowledge that legal actors are always making choices about whether to recognize race, we can think more productively about how and when and why we are doing it. Finally, I think that this account matters because it opens up ways of rooting present-day movement activism in a deep history of Black legal activity and legal thought. When we think about the history of legal thought, I think that the people who spring to mind are usually people like Oliver Wendell Holmes and Guido Calabresi. But I would submit to you that looking at working class people's discourse about law reveals a great deal as well. So for example, if we want to understand why, according to one poll, only 17% of Black Democrats consider themselves liberal, or why Justice Clarence Thomas thinks eminent domain is just a fig leaf for Negro removal. I think we have to look at what black people actually think about law, not just what they think about the rights America denied them, but also about the rights that were not denied them. Once we do that, we can start to put African Americans' relationships with each other at the center of African American history, including relations that involve inequality and subordination. Today, it's axiomatic for historians to say that black people have fought for, and I'll quote, independence in their working lives, autonomy in their families, for their families and communities, and equal citizenship in the body politic. But what did autonomy mean to Nate Shaw, who said that his own father treated him just like slavery? What did equal citizenship mean to black women who were treated and said that they were treated as second-class citizens in their churches and fraternal orders, the citizenship that mattered most, or at least most immediately, to black people before the movement? The story of African American history is, in no small part, about how black people struggled with one another, about what a black family, a black corporation, or a black community really was, and what its members owed each other. Barely visible through the veil of race relations, these struggles gleam from the shelves of the county courthouse in cases that were not primarily about race. Things like inheritance, partition, contract, divorce, and more. We should try to see black people's political and economic and religious and family commitments as more than echoes of America's original sin, more than signposts on the road to a more perfect union, more than facets of a struggle for black freedom. My basic premise is that black people's lives are worth studying in themselves. Thank you.
So we have some time for questions, and Hannah is getting the microphones, I believe. So if you want to raise your hand to ask a question, I will move you with the microphone.
Oh, hello.
Is it
In
on?
the,
Is it on? Check. Is it on?
This always happens to us in faculty meetings.
Just speak directly into the microphone, sir.
were the black clients of the area you were talking about dealing generally with white lawyers handing the fee over, and that would keep the structure feeling like, yes, we need them as customers? One of the reasons I think about this is because my grandmother was a legal secretary, we called them legal stenographers in the 1920s, and she was just blending over from the previous era, which was men. And the men would be in the law offices, and they were called confidential secretaries. But what they were is men who were in their pocket carrying a Webley British Bulldog loaded, and people would come in and make their property transactions, pay for a house in cash. There was a lot of money there. So if you...
That's what the Webley was for.
Yeah, the Webley was there, and they were men who sometimes had been policemen or just were big, and they would do paperwork and things like that. They usually wouldn't leave the office, but they would, unless they were with the attorney, and the attorney was going to the bank with them. But there was so much money moving through law offices, not just in fees, but in cash property transfers, that they didn't want to have women preparing that paperwork.
Yeah, I detect actually two really interesting questions. One is about sort of the presence of women in law firms, especially kind of small town law firms or big city law firms that are small solo practices. And then the other one is about who the lawyers were, whether these black people I see in my court records had lawyers, and if they were, who were they? And I'll just say, nearly every one of the cases for which I've been able to identify a lawyer, and it's not a lot, right? They often don't identify a lawyer or even a cause of action, actually. They're all white. They're all white lawyers. And furthermore, a lot of these lawyers are, in the 1882 and 1872 docket books, they're literally ex-Confederate officers. Like these guys were wearing the gray, and so I kept sort of thinking as I started this research, like, why is Colonel Sanders like representing these clients? And I sort of think, one answer is these clients could pay. And of course, they can pay either upfront, like a lot of these people are landowners. This is not, depending on the type of case they're bringing, they may have property that they can pay out of. Some of them are going to pay on contingency. So, for example, like James O. Eastland. I don't know how many of you recognize that name. He was chair of the Senate Judiciary Committee, and he bottled up civil rights bills for decades in Congress. Back home in Mississippi, he has a law practice, and he's representing black clients. A lot of it is just this kind of routine stuff, but some of it is against deep-pocketed white corporations, like a cotton processing company, things like that. So black clients can pay, and they are actually valuable enough as clients that in the 1890s, white lawyers drive black lawyers literally out of business, in part because of their jealousy to get these black clients. Black people's fees, man.
Black fees.
Yeah.
So one of the, I think, powerful revelations of critical race theory is that the system is rigged, and that there's consistent, systemic disadvantage against Black people frequently in the legal system, often concealed in what might seem like facially neutral doctrines. And whether, obviously, I think over time, right, whether this has come from revealing this in the academy as we do, or over just experience, I suspect it's the latter, that's surely led to a decline in trust in the legal system among African Americans, not just in the criminal context, but also in the civil context, I would expect. To what extent is the story you're telling part of that decline in trust? And to what extent have the disadvantages that have been baked into the system from the start part of this story? Is it have these successful regular uses of the civil system happened despite the disadvantages baked in, or are they sort of orthogonal to it? They're about areas of law where that hasn't been the central point.
It's a great question, and I think I would add that in addition to critical race theory, one of the big takeaways of some work in critical legal studies, or at least empirical legal studies, has been that the system is rigged in different ways. Like Mark Galanter's famous observation, the haves come out ahead. The question is, how do the haves come out ahead? And my work is deeply influenced by both of those sort of traditions. So I think that your question about a decline in trust implies that there was trust in one period and now is less. I actually think that Black people were pretty, when I say they had goat sense, I think that included in that is sort of a kind of clear-eyed, maybe not quite cynical view of what law can and cannot do for you. When they appear in court, I often get the sense, there's the case called Fald versus Pinn, where subject of the case, it doesn't really matter that much, but I see the litigants talking about their white lawyer in ways that suggest that that they are thinking about law as something whose outcome depends on who you know, or B, a matter of luck, or C, dominated by the powerful to the detriment of the weak, or D, something that can actually work for them at least some of the time. And I think that people typically held one or more of those ideas about law simultaneously in their heads. I'm not sure that it's that much different today, the way that people stand before the bar. But that kind of thinking goes way back in African-American lives. You can see black newspapers kind of putting that out there in these long serialized articles about, black people's uses of law.
Professor, thanks for coming by. Your interesting theories spark an interest in me because for the majority of my career, I've represented indigent folks in criminal federal problems. Roughly 80% are African American or other minority, so about 20% are white. Routinely, all the things you just said, the four things, their views of the law, all are there. The fifth one that I could use it to my advantage, rarely is it there. My question to you, though, is more fundamental, more practical. If I'm representing a 22-year-old guy who's facing, let's say, 5 years in federal prison, and he thinks the system has roughhoused him since he was, let's say, 12. You're saying in your theory, it sounds like, that there were people in the 20s, the 30s, in the Deep South who did trust the system enough at least to settle their divorce or their land sales through it. How do I convey to that young individual client of mine that the system is there not to roughhouse him, but in fact may be worth some trust, at least a minute amount, enough to get him through the system and back on the road to having a more productive life than sitting in prison while he's 20 and 30. I'm curious too, as a side note, the practical implications of your theory require deep education, it sounds like. How could one lawyer go about doing that when, let's say 80% of his clients might be receptive to that theory? Honestly, 100, because the other 20% don't have very different views at all anyway. Just curious what your practical help might be to me and to others in my situation.
Yeah, no, it's a great question. And I think, my first answer is going to be sort of a cop-out, which is to say I'm writing about civil cases. And I'm not sure, honestly, I'm not sure how far I can, extend the theory that I've sketched for civil cases to plant a seed of hope for someone who, is facing a long criminal sentence. There's the history, but, I'm not sure. The system does all sorts of things. The case that I just referenced, Fall versus Penn, it actually was a death penalty case. It was a young cousin. He was going to be hanged, and he got pardoned by the president. And the question was how did he get pardoned? Who should take the credit for it? And the family basically said, it wasn't this lawyer who did it. The lawyer was these white lawyers are trying to claim the credit for it, and it wasn't him. It was this petition that I got up and walked around Washington, D.C. and, convinced the President McKinley to pardon this child. So, yeah, I'm not sure how far I can extrapolate that. The question about education, requiring deep education, yes and no. Lawyers absolutely have a huge role to play. Lawyers are the ones who know law in the way that can enable you to appear before a court, right? You should not represent yourself. But what I'm saying is that maybe one practical piece, takeaway might be for those of us, at least who are social scientists, to begin to think about legal vernacular legal knowledge as something that can inform the strategies that lawyers might use. And I'm sure that this is no surprise to many of the social scientists in the room, and probably many of the legal practitioners in the room. But if there's a way to kind of think about, a client's existing legal knowledge and incorporate that into the strategy, that might be about as far as I'd be willing to go.
How about family support? Can you just go above that? Yeah, but you just have to really push it.
I was just curious about if you saw in areas like tort and contract and property, are you seeing any places where there are particular legal doctrines that have elements of subjectivity to them, like a meeting of the minds or the like? Are you seeing places where those are getting sort of applied in a warped way? Because I'm thinking of people in this house who won't let people be educated in the same schools, but yet they'll say there can be a meeting of the minds between white and black person. Or is there? I'm just curious if you're seeing anything where like doctrinal rules are being sort of warped with respect to race in the periods you're looking at.
I think I am, and actually I would revise your comment to say that I wouldn't necessarily characterize it as warping, because I think that implies that the doctrine was pure, that there was a time before there was race involved in the doctrine. Maybe back in medieval England there was, but some of the ways that doctrines absorb racial thinking is through equity. So that in the 1860s, many of you may know, the Freedmen's Bureau is adjudicating tons and tons of cases in the South, and they have to figure out how to reconcile freedom of contract with the thing that they think they know very well, which is that black people they're ignorant, they don't know anything. And what they come up with is this idea that black people are wards of the state, wards of the nation. And of course, this tracks with very old concepts about wardship capacity, right? So women, children, sailors on long voyages who are helpless under the command of the captain of a ship, right? Judges start to import these doctrines into contract law, and that actually plants the seeds for something that becomes very prevalent in the South. Gabriel Chin has written about this, the ignorant Negro strategy, right? So if you're a white lawyer, one way to sort of, argue a contract case is to say that my client, a black man, didn't know what he was doing, or he was overawed by this powerful white man who was on the other side of the table. There was undue influence, and therefore, the contract should be voided. The thing that I find really fascinating is, I think what happens is that, strangely enough, those ideas about the ignorant Negro, they get imported into the law of the poor in the 1960s. And you can kind of see it in the Williams case where, the judge is kind of saying, look, the reason that Orly Williams signed this contract is because she's ignorant. It's not because she had no alternative. That was in an earlier draft, but what they go with is she's ignorant, she doesn't know anything about the law, and therefore it's unconscionable. So that's kind of how I see things going. That's one example of where I see these race leaving an imprint on the law.
Well, join me in welcoming Professor Pendergraft for a great, thought-provoking lecture. There's a reception upstairs in Ben's place, and there are books also available for purchase and for signing. So please join us upstairs. If you need to take an elevator, there's an elevator ticket for accessibility purposes.